Okay, good morning, everyone. Absolute pleasure to be with you this morning. We are in the middle of winter, it seems, but not. We are adjusting to the new way of life and the new way of things, and it's always so nice to connect with everybody. We know it's been a busy time with the industry seeming to be back up and running within the restrictions that we still have on us, but still being able to do a really successful job of getting back to business, which is really, really exciting. As always, we're trying to bring you information and content that will help you navigate the journey ahead with the restrictions, particularly on our businesses, and whether you're an employer or whether the impact of having numerous staff at your events and your exhibitions, we know that that is quite impactful, and understanding how to navigate this within the current environment is really, really important. It's been a busy time, and because of that, we know that not many people are available this morning, but the session is being recorded. So we're very excited to be able to share that later with all the people that have registered and with our greater industry as well, because we do believe that this is really, really pertinent at this point in time. So what are we talking about? This morning, I have with me my colleague, Rian Filyoen from Filyoen Attorneys, and he's hosting our COVID-19 mandatory vaccination webinar. We're going to be delving into the potential impact this has on the reopening and the ongoing operational plans for society, and in particular, our space, the exhibition and event space. With many leading corporations in South Africa having implemented mandatory vaccines in the past several months, together with the recent awards handed down by the Commission for Conciliation, Mediation, and Arbitration, determining 2 mandatory vaccination matters, it is important to understand the debate regarding mandatory vaccination policies. So this particular webinar will help you familiarize yourself with the legal aspects of mandating a COVID-19 vaccine, but also the impact that this might have on our workplaces, our event spaces, and the future of our exhibition space as a whole. You've met Rian Filyoen, I'm sure many of you have. He founded Filyoen Attorneys. It's a niche legal practice. He operates quite heavily in our industry as well, and is our go-to on many issues, helping us to navigate our businesses in the legal space. He's been with us for a while. I mean, I'm not going to read to you his entire CV, but he offers numerous training courses. His practice concentrates primarily on commercial matters with specific focus on employment matters and commercial contracts. And he's had numerous matters conducted in the Labour Court, the Labour Appeal Court, and the High Court, and the CCMA. So he brings with him a world of knowledge and wisdom that will help you navigate your business and the exhibition space in a more comfortable manner, knowing that you have somebody like Rian at your side. So Rian, thank you so much for joining us this morning and sharing your wisdom with us. We look forward to the session. So yeah, I'm going to hand it over to you.
Thank you very much, Progeny, and good morning, everyone, and thank you for joining us. As Progeny said, with COVID, a lot of changes come about in our daily lives on a personal level and also obviously on a business level. And the landscape keeps on changing. It changes through where we were stuck in a lockdown, where we weren't able to go out at all, to now a phase where we're allowed to not wear masks in outdoors and go and exercise as we do or see fit, but also in terms of regulations and the dispense with the Disaster Management Act, which obviously has a massive effect in as far as the further regulations and the further steps that government is going to take. So I'm going to focus on 3 elements. The one is obviously the not so favorite, that's the legalese. The second will be, how do we implement a vaccination policy in our working environment? And then thirdly, how do we future-proof going forward? How do we exist in this exhibition space as you have done up until this point, which I commend you for, various ideas, virtual exhibitions, and all the elements that need to go with that in order to make it viable to start with, and obviously to make it safe for everyone who attends. So firstly, COVID is unfortunately here to stay. I've read numerous articles in as far as is it going to be diminished in its totality? And it's not. And we need to make peace with that fact. It's how we're going to manage it. And is it still a pandemic or is it now endemic? Well, in some of the countries where it was regarded as being endemic, we've now seen what happened in Hong Kong. It then again began to have a resurgence as a pandemic. Went into lockdown. We saw it in the Netherlands and also other parts in Europe where certain protocols were relaxed, and then immediately after the relaxation takes place, winter steps in or seasonal change, and then things get a bit difficult again, and they go back to, well, basically what the status quo was prior to lifting or relaxing certain protocols. Our most recent relaxation was on the 22nd of March. It was the Government Gazette, where certain of the regulations were changed, and I'll deal with those a bit later. And as far as the exhibition space is concerned, and Progeny will amplify my view that I still not regard the definition to be correct, but we are now stuck in that definition under gatherings, which is the same as fitness centers, casinos, entertainment facilities, but they then make specific reference and they actually use the word exhibitions, where we find ourselves in. But I'll deal with that a bit later. So firstly, one has to consider what are the elements that play a massive role or play the biggest roles in the whole mandatory vaccination drive. And as Progeny correctly pointed out, a lot of corporates have instituted mandatory vaccination policies. And I think therein lies the first disconnect. It is what we are going to call this thing. If you want to implement it in your working environment, I would rather venture to call it a return to office plan or policy. The moment that we start labeling it mandatory, which I believe also has a bit of a punitive connection to it, I'm telling you that you will. And human nature is, we don't normally like people telling us what we should do if we actually don't want to do it, or if we don't actually understand it. And there comes the second part. Like we had with HIV and well, specifically HIV in the mining industry a couple of years ago, it was a drive to educate. And without that form of education being implemented either through government or through employers or by ourselves, the less educated people are about a problem, the more reluctant they are to adhere to the rules associated to that problem. Now, in terms of the whole argument regarding, can I institute a mandatory vaccination policy or not? The first thing that we need to go and look at, and this is the one that is brought up by numerous employees, is the Constitution, my rights. Now, I'm all for rights, and I love to enforce those rights for and on behalf of individuals and companies. But the specific one that we need to, what we need to be specific about is that no right is absolute. And in terms of Section 36 of the Constitution, a law of general application may limit a right. Now, firstly, there is this right, but it may be limited. But now there is a proviso. The proviso is that its purpose is sufficiently important and its effect is proportionate. So when I start limiting a right, it has to be proportionate and important to limit that right. So that's the first hurdle that one needs to get across. Now, the only constitutional right that may or is possibly directly infringed by a vaccination policy is the right to bodily integrity, which we find in Section 12 of our Constitution. So although, and I'm very mindful of the fact that some individuals or employees or people may speak about their right to religion or their right to belief as being infringed, this right itself is really a right to free exercise of that religion and belief. And a vaccination mandate that applies generally across the board does not infringe the exercise of that religion or right. We refer to it as being a species of that right. So the main issue here is the right to bodily integrity. And in any constitutional argument, the first thing that you have to demonstrate is that the right has been infringed. And so far as bodily integrity is concerned, that it is clear that a mandatory vaccination will mean that there has been a health intervention without consent. Then there's an infringement. We sometimes hear it as employers that employees may say to us, you are discriminating against me, or you are victimizing me. Okay, how am I discriminating against you? And I think there must be a conversation about that. How am I limiting any of your constitutional rights or your fundamental rights, for argument's sake, by telling you that you should do your job? It's not because you are a Christian or a Muslim or black or white or a male or a female. There's a certain function that you need to fulfill, and I am the manager or the person who tells you to fulfill that function. So a lot of times people throw around these buzzwords with the aim of either distraction or being misinformed. Now, when it comes to the whole argument of religion, and as I've already said, it does not interfere with the right. If one looks, for argument's sake, at a very interesting case that was held by the United States Supreme Court, which involved the Jehovah's Witnesses, it held that a neutral law is applicable, but it's only applicable to all religions, however, restricts a tenet of that religion, but it does not necessarily mean that there is infringement of that right. In other words, the other right that is often also referred to is the right not to be discriminated against. And the arguments that I'm going to raise, or that I'm going to highlight to you, is that there is indeed a limitation to the right to bodily integrity, that if discrimination is the case, whether it's implied equally and whether it would be fairly applied or not, whether it's rational, and whether its intent is there to attack people, disarm them, harm them, or basically diminish the rights that they have, in which they're held in the Constitution. Now, what we need to take into consideration is that there is no specific statute or law that regulates COVID-19. We get it in the regulations, and there's a work skills development plan and all of those things, but there's no COVID-19 statute. So where do we get it from? We basically need to go and look at the current piece of legislation which does play a role, and that is the Occupational Health and Safety Act. To a large extent, the common law principle of a safe working environment is encompassed in the OSH Act, or OSHA, or Occupational Health and Safety Act, and the aim of this act is to specifically provide for the safe and healthy working environment for employees in regards to how they use machinery or how they go to the office, and it is there to prevent any or avoid any work-related injuries or illnesses. Now, specifically Schedule 8 or Section 8 of this Act is clear and unambiguous, and it imposes a statutory duty on all employers to take reasonable practical steps or measures to ensure a healthy and safe working environment. It reads as follows: every employer shall provide and maintain, as far as reasonably practicable, a working environment that is safe and without a risk to the health of its employees. It goes a bit further and says the employer should take such steps as may be reasonably practicable to eliminate or mitigate any hazard or potential hazard that to the safety or the health of its employees before resorting to PPE or personal protective equipment. It also says every employer shall conduct in his or her undertaking in such a manner to ensure, as far as reasonably practicable, that persons or anyone other than those in his or her employ who may be directly affected by his activities are not thereby exposed to hazards to their health and safety. So just by reading this and going into the essence of OSH, or the Occupational Health and Safety Act, that would be the piece of legislation that one will apply in ensuring a safe working environment, i.e. mandatory vaccination policy, or, as I said, a return to office policy. The Act goes further and determines that every employee at work must cooperate with an employer who has imposed measures to obey health and safety rules and procedures laid down by that employer, which is in the interests of health and safety. So there's very little doubt that the requirement to vaccinate is nothing less than a reasonable, practical step that every employer is required and actually compelled to take. Now, if we move away from OSH, or the Occupational Health and Safety Act, we must go and look, and I like to use the word species. We must have a look at what are the common grounds for dismissal or termination of employment. And the three main ones are misconduct, incapacity, and poor work performance. But there's also a fourth one, operational requirements. Now, if I have an instruction that I need to fulfill, which is reasonable and justifiable, i.e. everyone who is client-facing should do two things. One, they should be fully vaccinated, or they should submit a PCR test, which is not any older than 72 hours. That test then will be, the test that will be then applied is that instruction reasonable and justifiable? Now remember, we have OSH. So I'm working from a statutory point of view where I need to take into cognizance that I make the working environment safe, not only for my people, but for anyone else that deals with my people. So my argument would then be, well, it is a reasonable instruction. And I'll deal with when an employee does not want to submit or does not want to comply with that instruction. But on the face of it, it's reasonable, it's justifiable. An employee or person does not want to comply, that's a form of misconduct, species one. Species two, I have a person or an individual who is client-facing. They are either medically not in a position to receive the vaccine, let's take that first, and that would then render them incapacitated. Now, obviously, we start talking about reasonable accommodation, which I'll deal with just now, but now it's a second species, incapacity. The third species would then obviously be the operational requirement. I need you to be client-facing. I see it come about more often every week almost with clients that have placed individuals in their clients' premises. We get a notification or a memorandum from that client saying, we are, like with the Sasol matter, we are 100% vaccinated working environment. If you wish to place anyone here, you should do the same. Now it becomes an operational issue. Forget about misconduct, forget about incapacity. I need someone to be operationally effective, be vaccinated, to service the client. That individual does not want to either get vaccinated or cannot get vaccinated. So you can either go back to misconduct or incapacity, but it also then renders the species of operational requirements, which will then follow suit, i.e. the position that you are employed in is client-facing. However, you are unable or unwilling to fulfill that position. And technically speaking, with that position comes the requirement that you are to be vaccinated. Old position, no vaccination needed. New position, vaccination needed. You cannot comply. So the old position effectively becomes redundant. Simple example, I have a driver. He needs a license. His license has expired. He is now illegal on the road. Are you going to employ that driver and run the risk from a vicarious perspective? I doubt. So this will also apply to our employees being deployed to clients, as I've stated. However, the final issue, and as far as OSH is concerned, is that it's actually a criminal offense for employees not to obey the health and safety rules of its employer. The same goes for the Mine Health and Safety Act. But however, the question then is whether mandatory vaccination is a reasonable, practicable measure, and whether the natural answer is a preemptive yes. However, there are steps that you will have to take prior to getting to that point. Now, the Disaster Management Act has been disposed of, and we are cautiously optimistic and waiting to see how the new act will deal with the various different protocols in conjunction with the regulations. Now, I spoke about reasonable accommodation. What does it mean? Employers are therefore obliged to try and accommodate their employees who are regarded as being incapacitated or unable to perform their jobs in the manner required by us as employers. Now, in terms of the LRA, or the Labour Relations Act, dismissal is only the appropriate sanction in the case of incapacity if the incapacity can be proven and no reasonable accommodation could be found for the employee. This was obviously amplified, and Progeny mentioned it earlier on, in the recent CCMA ruling dealing with the issue of incapacity due to an employee refusing to adhere to his employer's mandatory vaccination policy. Now, the LRA permits employers to dismiss employees for valid reasons, subject to a fair and proper procedure being followed. So practically, this would mean that an employer must reasonably try to accommodate the employee by offering him or her the option to work remotely, if possible, or alternatively taking up a different position, if it exists, and or engage in consultation to try and persuade that employee to be vaccinated. If these courses of action all fail, the employer may then be at liberty through a due process to dismiss the employee on any of the grounds as recognized by the LRA, being misconduct, incapacity, and as I've mentioned, operational requirements. As I said also, the refusal to obey a health and safety rule, which endangers others, constitutes a serious misconduct. And in fact, in terms of the Occupational Health and Safety Act, the employee's failure to this rule or failure to adhere to this rule can be regarded even as a criminal offense. The scenario is also difficult to explain in different environments, but I believe in our environment, in the exhibition industry, we work with people all the time. Yes, we might have a finance office or a back office where people do not engage with clients or with exhibitors. But at the end of the day, I think a core function of why people want to go to exhibitions is not only for the exhibition, it is for the interaction. Why else would we go? Otherwise, I could just buy stuff online. I want to go and I want to touch stuff. I want to feel it. I want to see it. I want to engage with the person selling it to me or marketing it to me. We are that bridge as an exhibition industry. So not only will you have to focus on your environment, you will also have to focus on your exhibitor's environment. And this will obviously then trickle down into your exhibitor's terms and conditions. Are they adhering to the protocols? Are they in line with the statutory requirements to create a safe gathering, safe exhibition for the general public? How do we limit liability? What if, now I'll use Progeny's exhibition as an example. I have a 5-month pregnant mommy that attends Mama Magic, attends our exhibition. And for some other reason, 4 days later, she has now discovered that she has contracted COVID. Who's liable? Do we set up an indemnity form or an indemnity stand or poster which we say, you enter these premises at your own risk? Well, quite frankly, we'll have to. But we all go to Woolies or to Pick and Pay, to Checkers, basically every second day or third day, depends on how big your family is. I have not seen an indemnity sign there, except for these premises are entered to or entered by you at your own peril. And should anything bad happen to you, then we can't be held liable. That should be sufficient. So again, we need to start thinking logically about how this whole thing interacts with us. Now, coming to what does it do for us in the exhibition industry? The regulations have changed, and I'm going to read them to you. They've replaced Regulation 69 by saying the following. All gatherings, including faith-based or religious, social, political, and cultural gatherings at restaurants, bars, shebeens, and taverns, at conferencing, exhibitions, dining, gyms, fitness centers, etc., where persons who are, first condition, fully vaccinated and in possession of a valid vaccination certificate. Now, let's just stop there. The Act does not, or the regulation does not now include boosters, but let's accept that this should include boosters. It only says vaccination, fully vaccinated. And then the second condition is if they are unvaccinated and not in possession of a valid vaccination certificate, they then need to be in possession of a negative COVID-19 test recognized by the WHO, which they had obtained 72 hours before entering your premises. Then they are, so that's condition 2. So if I don't have a fully vaccinated individual, then they have a test. Then they are allowed at up to 50% of the capacity of the venue, provided that entry to the venue is conditional upon production of the valid certificate as referred to above, or the test, and then another condition, strict adherence to all health protocols and social distancing. Now let's unpack only that part for now. 1, policing. If I buy a ticket to go to the exhibition, is there a little block which I fill in to say that I have been fully vaccinated? Yes, no. Do I then attach it? Do I send it? Do I email it? Do I carry it with me? Like I've got mine literally on my WhatsApp profile picture. It's easy to reach, but I'm vaccinated. Or am I going to then conduct the policing at the entrance? So everyone that has been vaccinated, fully vaccinated, double jab at least, they can go in. But I'm hitting a second wall here, because regardless of all of this, regardless of the vaccination, what the current regulation states is 50% of venue capacity. So if we take, for argument's sake, Nazareth, that would be X amount, 1,000 people, 50% of that. Now what it does is it goes a little bit further. It now also caters for complete non-vaccinated individuals and also people who don't have any test results. So it says here that people who are, or persons who are not fully vaccinated or in possession of a valid certificate, or unvaccinated, not in possession of a COVID-19 negative test, then we are allowed, but limited to 1,000 people indoor and 2,000 people outdoor. However, the 50% capacity rule still remains. So obviously I can't fit 1,000 people in a small venue. So then you fall back on the 50% capacity. You can take 200 people, totally unvaccinated, no negative tests. So I can only allow for 100 people. It says further that the owner or the operator of any indoor or outdoor facility where these gatherings are held must, and one must be very careful when reading these pieces of legislation. There's a massive difference between may, can, and must. Must is a direct instruction. You must display the certificate of occupancy, which will set out the number of maximum people which the facility can hold. So that is our responsibility. Now, currently, that is where we are at. So we are either going to have to implement measures in which we can establish vaccination status, which obviously then comes together with a PAPIA requirement, because that's medical information. And how do we safeguard that information? That's a totally different discussion. So it is going to be a bit of an uphill battle going forward. You guys know this. However, that is what the requirement says. Further to this, and here comes the stinger, is that if we are not compliant with these protocols, with these regulations, you do not only face the possibility of a fine, you also face the possibility of criminal, of being incarcerated, criminal record. And I believe that the jail time, if I can call it that, is up to 6 months. It's and or, so you can get slapped with a fine and go to jail, or you can just go to jail or just get a fine. Now, I doubt people will be going to jail. I don't think that will happen. I think our criminal procedure and criminal justice system is overloaded as it is. But to institute fines is not that difficult. So be aware of this. And it's very important that we take cognizance of it, given the industry that we are in. If we have exhibitions where these measures are not met, all the hard work that has already gone in to get us at least to this point will be undone. We only need one bad apple to ruin the batch. So it's very important that as a group of people teaming together, trying to get the industry going again, that we take cognizance of these requirements. And when they change, which I believe they will, we will adapt. And eventually, I believe that we will go back to some sense of normal. But currently, it is the position that we are facing, or the position that we find ourselves in. Now, further to this, one must also then be cognizant of the fact that now, how do I implement this vaccination policy if I want to do it. Now, in June 2021, there were a couple of directives that were replaced, but the main issue here is that you as an employer within your own environment. So remember, we're working twofold. One is internal, and then the other obviously is external. But if we want to implement this, you have to do a risk assessment. You have to consult on the risk assessment with your employees, with your associates. The plan must include the date when we will open up and what the hours would be for working. It has to have a list of permitted employees who will be returning to work. The plan must have a timetable for a phased-in return to office approach. And that's why I rather would refer to it as a return to office policy. It's a blanket term. It doesn't actually go as far as saying, oh, this is a mandatory vaccination policy. But it encompasses all these requirements. It must show the ways of minimizing the number of workers or employees at the workplace. It must also identify vulnerable employees at the workplace. The workplace, what we have done at the workplace and as far as protective measures are concerned, and what these directions are, and are they compliant with the latest regulations. The measures for daily screening of employees, and also then important screening of clients, contractors, and any visitors to our workplaces. The details, and obviously you need to employ or appoint a COVID-19 compliance officer who is there to resolve any issues that may arise as a result of the existence of your phasing back to work policy. So firstly, risk assessment. Second, consult. Now, consultation is not negotiation. We all know this. I have a plan. I have something that I need to do, but I want to take you with me on this journey. I want to talk to you about it and see how we can find measures to have a joint, meaningful, consensus-seeking process. But the target remains. The target is that I'm going to employ a return to office policy and plan. We need to find the route to get there. That's a consultation. There is no give. Yes, there might be additions or subtractions, but from the core value of what I wish to achieve, I cannot detract. That is a non-negotiable, hence why it's called a consultation. And then after that, there will be consolidated directives that will be of importance for us to deal with. Every employee identified by the employer in terms of the act should be notified of his or her obligation to be vaccinated, as and when a vaccine becomes available for that employee. And the right of the employee to refuse to be vaccinated on a constitutional or medical ground. Now in comes what I mentioned earlier on, reasonable accommodation, where we now as employers need to go and find a reasonable accommodation for employees who have a valid medical reason why they can't be vaccinated or a constitutional reason why they can't be vaccinated. Now, if the employee refuses to be vaccinated on any constitutional or medical ground, the employer should then counsel the employee, refer the employee for further medical evaluation, and if necessary, take steps to, you guessed it, reasonably accommodate that employee. So it is a lot to be done for all of us. Now, is it impossible? I don't believe it is. But where a decision is made that employees should then return to the office, all the COVID-19 protocols set out, and I've mentioned briefly, should be adhered to. The issue of enforcing mandatory vaccinations will prevail, as we are at the behest of our clients in most instances, and now also at the behest of an industry. Should you wish to introduce a policy, it will have to cater for both client and customer-facing employees, as well as employees who do not have such interactions, although the issue of creating a safe working environment and that obligation will always remain. OSH. And then if we were not to go and look at what a return to office policy should look like, just to give you a couple of examples. Like with all policy, it has to have a purpose. Why are we doing this? It's an introduction. I always use the example, why would I ask when I was dating my wife, why would I ask her for her number? There was a purpose. I want to take you out for coffee. So I need to explain to whoever's reading this policy why I'm doing it. I need to create a rationale for why I'm doing it. I can't just go and grab it out of thin air. Then you can always consider the issue of a hybrid operating model. Some of our individuals or some of our associates do not need to come to the office. And the argument is clear. I've seen it on numerous occasions, is I've been working from home. We're doing webinars, but I've been working from home for 2 years. There's been nothing wrong with my performance. There's been, in actual fact, you promoted me. You gave me a raise or an increase or a bonus. So why should I come back to the office? If that is applicable and can suit your business, then apply it. Don't need to have everyone back at the office. The world has changed. People work from wherever they want. My argument is normally, or my view on it is, my target, your time, but you should reach the target. Whenever you do it, that's your problem. But if it's done, or it should be done by 9 o'clock on a Monday morning, and it's done, good for you. Then there's also not only the hybrid model that you can institute or introduce into your business, there's also the in-person protocols. How do we deal with people that now come into our offices, clients, exhibitors, not only our own staff, but obviously they have interaction with one another. And in that instance, my argument would be that not only should they be wearing face masks, which we all know is indoors, but also that they will practice the necessary social distancing protocols, sanitization, and as per government instruction. Again, education. People need to know this. Yes, I know that when we walk in an airport or get onto a plane, which completely is weird and illogical, but be that as it may, before we get on the plane, there are seats open and there's a 1.5 meter rule. What happens in the plane still confuses me a bit, but anyway. Then obviously we need to make resources available to our employees. Resources in the sense that they need to know where they can get vaccinated. We need to, if they want to or wish to get vaccinated, there should be time off. And herein lies another element which one should consider. What happens if an employee contracts COVID? Doesn't matter now where. Let's say they contracted it from a party or a wedding, and they no longer have any sick leave. Does that then mean that they should be on unpaid leave? The answer is no. So yes, you do not need to necessarily pay. However, the opportunity should be given to the employee where they can apply for sick leave, i.e. remuneration in terms of sick leave, and that they can obviously do in terms of the, I'll just think about the word, the unemployment insurance fund. So they can apply for that. But if it's unpaid, if the sick leave has been depleted, then it is unpaid. It's not your responsibility as an employer to keep on paying someone who's not at work. However, the resources must be made available to them in order for them to make that application. Obviously, then there will be entry requirements into the offices or the premises of the employer. And now you have options: vaccination or testing. People who do not wish to get vaccinated should produce or present a negative COVID-19 WHO recognized test with a 72-hour lifespan. Want to enter the premises? You're welcome. Where's your test? Alternatively, if you are vaccinated, show me your vaccination certificate. What happens if there is now non-compliance? An employee who is not fully vaccinated and self-attests to have not been fully vaccinated and who is not compliant, firstly, cannot be disciplined. Secondly, cannot be discriminated against. And thirdly, should then raise a dispute, which will be run through your COVID-19 or your return to office policy. The dispute will be regulated and determined swiftly and expeditiously by the COVID-19 compliance officer. So if someone refuses to perform any work in terms of a COVID-19 vaccination, that dispute and concern must firstly be addressed before we institute any proceedings. Obviously, there's also the issue of monitoring, and to make people afraid with the fact that if you are exhibiting any symptoms, you should tell us. There should be other controls and protective measures imposed by the employer. And what do we do if someone needs to isolate? Now that's changed. 5 days, if you've got no symptoms, you can come back to work. Well, that you can put in your policy. But obviously, again, OSH, reasonable accommodation. Can I introduce it? What is the capacity? Am I at 50%? Happy with that? And how do I implement it? Well, you can book seats. We work on a schedule. There is a roster. So it can actually be easily managed by us as employers. And the last thing that you'll need to comply with, or that you'll need to insert in your COVID policy or your return to office policy, would be a compliance officer. The employees or people need a port of call to who they can go to if they have a dispute, if they do not wish to get vaccinated. And that individual needs to resolve these disputes and issues and bring it to the attention of the relevant managers or HR to deal with it. It's something that we simply can't leave to chance. So in conclusion, we need to firstly implement, if required, and I also know of a lot of employers where the owners or the CEO is anti-vax. And the example shines through. It is still your choice. Nothing in the act or in the directives say you must. However, if I take in balance the requirements of the Occupational Health and Safety Act versus the limitation of the constitutional rights, then my argument would still be, we'll be found wanting if we do not secure a safe working environment for our people. And as far as the exhibition spaces are concerned, let's do the best we can to follow the directives to a T. Yes, there are numerous gaps in the directives. And yes, they are unfortunately open for interpretation. But my advice would be, err on the side of caution when you wish to start interpreting the directives and what they imply. I know it's going to be difficult. However, I believe, given what we've been through the last 2 years, more than 2 years, it is something that we can implement, something that we can overcome. And we need to be cognizant of the industry and the future of the industry. So good luck. And I trust that this was informative in as far as what this vaccination drive should be. Be careful what we call it. And basically stick to the rules. That would be the key.
Thank you. Thank you so much, Rian. Definitely a lot of information to digest there. And if any of you have any questions, please feel free to put it on the chat, and Rian will be sure to answer it. We try to keep it as tight as possible to give you an opportunity to ask questions, because I know there's a lot of questions here. So from my side, I have a couple that I'm going to shoot with, if you don't mind. So
sure.
As a business, can you refuse to do business with an organization that is not fully vaxxed? So if I'm contracting the services of a supplier and I want to know if their staff have been fully vaccinated, and if they say no, could they take me up on that?
So the answer is yes, you can refuse to do business with a company if your stance is 100% vaccination at my premises and you wish to enter. Let's say I'm your aircon repairman and I'm like, no, I'm not vaccinated. Then no, you don't need to do business with me, because by doing business with me, you are actually in contravention of the Occupational Health and Safety Act. You're bringing in the danger into my business, and I can't foresee or see to it that I've got a safe working environment, not only for you, but for my people. So yes, you can refuse to do business. Well, again, the Cook Cecil matter, that was clear. And I said, sorry, your security guard cannot enter our premises because he's not vaccinated. And that was what gave rise to the incapacity argument. So to answer the question, yes, you can refuse. Obviously, rationale, grounds, reason, it won't be a blunt refusal or complete denial, but we need to then make your position clear. So yes, you can.
And then in the same vein, when we talk about, I mean, there I'm talking about, suppliers but what about employees? If I am sitting in an interview, can I legally ask the question, are you vaccinated? Can it be one of the requirements, in my preamble to the interview even? And can I refuse employment based on non-vaccination?
The answer is no. It would be the same argument that when you ask, would you ask a female employee, are you pregnant? You won't. Would you ask any employee, are you HIV positive? You won't. Can you ask, and I won't even venture doing it, but I know that some employers would go along and say, would you be planning a family soon? And that's really walking a thin line. So what I think should be made clear to the prospective employee is to say to them that we believe in a culture of safety and security for all our employees. Given the COVID-19 pandemic or endemic, we believe in the 100% vaccination principle and policy. And should you be successful, then obviously you'll need to adhere to those principles. And what will happen, let's say the employee at that stage does not declare whether which they won't, whether he or she is not vaccinated. They are brilliant in as far as what they can do, and you then employ this employee. Now the employee rocks up and says, yeah, actually, I'm not vaccinated. Well, I made it clear during the interview process that you should be. Well, we believe in 100%. So no problem. You don't want to be vaccinated? Well, then you have to bring a PCR test every day you come in. And also then comes in reasonable accommodation. If I employed this person to be a coder or an accounting person, and they do not need to be in office or client facing, it can be accommodated. But I would not necessarily go as far as saying, well, if you are not, then you won't get the job, because we don't have enough information to justify that decision. This employee might have a comorbidity, might have a medical reason why not, might have a religious reason, or whatever the case might be, which they at that stage do not want to divulge or disclose, because it is an employment or it is an interview. So to come out, I would flip it around. We believe, can you fit in? Will you be able to fit in? So you're asking the question with actually asking the question. And if they then say, oh no, I'm happy to do whatever is required, and they get employed, then you'll need to move to phase 2 or 3 in as far as the testing is concerned or imposing the vaccination policy.
So then,
but I would be upfront.
The same would apply, for example, if I am a supplier and the project requires, my client requires a fully vaccinated team. So now I need to go employ staff to fulfill this project. Then can I ask? Yes,
then you can. I'll use the example of, again, a licensed driver. There's a specific task that has to be fulfilled, and there are specific requirements. So for this client, for this independent contractor, for the service provider, in order for you to do the job, in order for you to be on the premises, your team needs to be vaccinated. That is a material obligation. In an SLA, it's easier. So if you can't fulfill that obligation, obviously you are going to be in breach. And if you are in breach, as you know, what we'll do is we'll put you in breach. They can remedy it 14 days, whatever the case might be. And if they're still unable to remedy that breach, the agreement will terminate. Will terminate. So yes, but it's far more where if I know the parameters of the requirement for which I employ the services of a service provider, and the service provider knows that, and it's exactly the same as in the interview. I'm already giving you my requirement. I'm saying to this individual, X, Y, Z. Your issue is that the relationship is completely different. It's now an employee-employer relationship, and it's governed by a different set of rules, i.e. the BCA, Employment Equity Act, and the Labor Relations Act. Where with the service provider, it's commercial in nature. This is what I need you for. These are the requirements. Can you meet those requirements? Yes or no? It's like if you employ me, Rian, are you an admitted attorney? Yes, I am. Okay, then you can go off to the High Court and represent us. Rian, I need an attorney. And I keep quiet. I'm not an admitted attorney. I'm not allowed to go there. And you give me the brief. And now I said to you, Progeny, sorry, I'm not actually admitted. I can't go to court for you. We don't have a relationship. Can't happen. Can't work. Does that answer your question?
Yes, it does. Definitely does. Let's see, is there any other questions on the chat? No. Another question for me then would be, with regards to, I know we spoke a lot about our exhibition space and the 50% capacity and the 1,000 packs. And I do agree there is a lot of burden on us right now to make sure that we don't infringe the rules, so that we're not put into the spotlight. But have you had any cases thus far where, whether it was a mall or whether it is an event, or has there been any cases thus far where people said, I know that I have picked up this and I'm taking that organizer or that business to court?
No.
Okay.
No. So here's my argument on that one. This is not the US of A. If you burn yourself with hot coffee, you are an idiot. Unfortunately, they don't regard people as idiots when they spill hot coffee on them, and they sue McDonald's because I've got a blister on my hand. But luckily, our law is not as forgiving as that. So when you enter a premises where there are a multitude of people, or there is a multitude of people, you accept the risk inherently. But I would still advise to say there should be an indemnity. We should indemnify ourselves as event organizers, just to be on the side of caution. But every time I get on a plane, I accept the fact that if something goes wrong, it's going to go wrong badly. Whether I get COVID or whether the thing drops out of the sky, I'm still getting on the plane. So yeah, you need to. It's an inherent risk that you need to accept. So short answer is not that I've seen, and I also believe, obviously. So if we go to Gold Reef City, which I haven't been to since a child, but let's just go through that example. They give you this when you go paragliding or when you go bungee jumping or whatever the case might be. They give you this lovely indemnity form. They even give it to you when you go to a hospital, right? Now you can never contract out of obligation or right. That's contract law 101. I can't make you sign a document and then act in a negligent manner to your detriment or damage, and then pull this thing up and say, sorry for you, you indemnified. So if that ever should happen, and the claimant or the plaintiff can prove that that exhibition did not follow COVID protocols, did not have sanitizer, did not follow 1.5 meter, blah, 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 all of these things that we have the map for, maybe then, because then you were negligent. And as a result of that negligence, the disregard or omission for the statutory requirements, I have suffered harm. Maybe then, but it's a long push. To quantify it, it's like when people, and we call them slip and trips. People slip and fall in malls, and they bash their heads, and then they've got memory loss. Okay, was there a sign? What type of liquid was it? Was the person notified or made aware? If not, you are in trouble. But to quantify that damage, it's an extremely difficult process, super costly. So to answer the question, currently, I've not heard of anything like that. But if it does happen, and there are valid grounds to prove negligence, and there was actual damage which can be quantified, it's a possibility. But at this stage, no.
And in turn, have there been any cases where employees have contracted COVID at the office? Has that been an issue?
That has been an issue. That has been an issue. We've had a couple of those matters. It's in the mining industry specifically, where the employee will raise a dispute in which not a dispute, will raise a concern which indicates that I went to mine X and 4 days later I was sick. Okay, let's investigate this. Did you sleep at a hotel? Yes, I did. Did they follow protocol? Yes, they did. Okay, then, so you start eliminating the possibilities. Did you go to the mall? Yes, I did. Did you watch a movie? Yes, I did. Okay, so where do you think you got the COVID from? It's because it's so absolutely random. It's very difficult, but okay. If the employee in the course and scope of employment and business contracted COVID, obviously the employer should be more lenient in as far as sick leave and allowing the employee to stay at home and work reasonable accommodation, assist, give resources. And if the sick leave is depleted, assist the employee to make the application to the unemployment insurance fund. I won't just abandon or divorce this employee. It's the same if someone falls off a ladder while screwing in a light bulb at the warehouse and they break their backs. Obviously, if it happens in the working environment, I as the employer need to take a bit more effort to accommodate that employee. So yes, we've heard of it and they complain and they have their issues, but normally through the process of elimination and actually not exposing, but showing the employee, okay, there are a plethora of places where you could have got this. Do you agree with me? 99% of them go, yeah, it's possible. You know, I went to a family gathering or a wedding. I'm not sure exactly. It's also very difficult to trace. You know, we say it's an incubation period of 4, 5, 6 days. For some people, it's 4, for others, it's 3. You know, I've had it 3 times. I know only of the third time, I've got no idea where I got it. The other 2, I know exactly where I got it. So, you know, because it was still very young. COVID was young. But the last one could have been on the plane, could have been in the mall, could have been anywhere. It's difficult. So yes, you get it, but you can easily deal with it.
Agreed. So I think ultimately we all need to approach it with caution in terms of the vaccinations being mandatory, making it mandatory at the office, and in our exhibition spaces, take note of it and let's not be in the firing line and putting our industry in the spotlight. I mean, I think particularly now with social media being so in the now, so immediate, and people having access to watching what is happening at various spaces and capturing the footage, the evidence can be right there in front of you, even though you might think you've followed all the protocols. So it's really, really important that even though we're managing the numbers, we're managing our people at our businesses and at our shows, but it's important to acknowledge that this is happening. There is footage being captured and you really don't want people to be pointing fingers at you. We all want to do business, I think, in the best way possible. And we're hoping that obviously that this regulation will fall away. It cannot be go on forever. And we're hoping with our submissions to COGTA and with our submissions to the Department of Health that we'll see some new revelations by the end of this month. But Rian, thank you so very much for your time this morning.
Pleasure.
We appreciate the input. It's been very, very valuable to us. I'm sure if there's anybody that has any further personal questions, Rian is available. You can contact him directly as well. Your email, Rian, would be?
My email address is Rian, R-I-A-N, at FilyoenAttorneys.com. And office line is, well, sorry,
yeah.
I beg your pardon.
Go for it.
Office line is 011-029-9090.
Yeah. So there you go. If you want to contact Rian's office, please do so. You can drop him an email or call and you know, tackle your issues there specifically. But again, to all of you, thank you so much for joining us. We are going to share the link with those who couldn't make it this morning because we know it's going to be valuable to them as well. Coming up, I think in the months ahead, I know there's been a lot of exhibitions that have happened thus far, and we're going to be putting some of those organizers in the spotlight to maybe guide us and share their experience and their knowledge to date to help us take the next steps forward. And obviously we know within the next 2 weeks, the spotlight and what information government shares on how the regulations will move forward is going to be very important to our businesses as well. So thank you all for joining us. Thank you, Sean from DMG, for hosting us. And thank you, Rian, for your time. Have a wonderful day.
You too. Thank you, Juan.
Thank you.